case, and then we will begin.
Just one moment. The first and only case is 2020 P1236 Innovated Mold Solutions Incorporated versus Hanover Insurance Group Incorporated and others.
Well, good morning, Council. I'm Justice Eric Neyman. Welcome to this sitting of the Single Justice of the Massachusetts Appeals Court. We will hear first from the counsel for the petitioner, Hanover Insurance Group, and that is Attorney Melville. Good morning, Counsel.
Good morning, Your Honor. If it pleases the court, today before the court is Hanover Insurance and the Hanover entities petition for leave to file a Rule 60A motion with the Superior Court to correct a clerical error. That clerical error would be the addition of prejudgment interest on an award of attorney's fees that was entered in the lower court.
So, Attorney Melville, let me stop you there. I have a number of questions. My first is this. What is my standard of review on this case? And by that, I mean, under what standard would I be allowed to send this matter back to the Superior Court?
I believe, Your Honor, under 60A, it's with leave of court. So I don't believe there is a stringent standard on this one. I believe it is appropriate for this court to allow it to be sent back down to the lower court.
Is it discretionary under 60A?
I believe 60A says with leave of court. I don't know that it's necessarily mandatory, but I think that would be an appropriate situation to be done on this one, Your Honor. I'm not sure.
Go back to my question. Is it discretionary?
It allows leave of the appellate court, so I'm not sure it is mandatory, Your Honor. I think there may be some discretion on this. Frankly, I've not seen a lot of case law on the issue of the standard of review. So I'm not I don't want to say it's necessary, but I think it's appropriate under the circumstances.
So is the lateness of the filing of this motion something that I can take into consideration in my analysis?
I don't believe the lateness should be it should be foreclose this issue, Your Honor. If it's
That's not what I asked. So it's really important to answer the question that I asked. And this will go more quickly, but
I apologize.
No need to apologize. You're advocating. That's fine. My question is, can I take that into consideration? Here we have an approximately 2-year lapse of time before you brought this motion.
I'm not sure that I don't believe the lateness should be a factor in this one, Your Honor. I think the cases where the courts have said that there was lateness was a factor and foreclosed the motion is something the court should have done, was situations where the case had already been the appeal had already been previously decided, not during the pendency of the appeal. That was the Frank D. White and Associates case, 394 Mass 619.
Yep. Well, what about the language of O'Malley, which you cited, footnote 3, which I know says that 60A may not be used post-appeal, and we're not post-appeal, to correct a miscalculation of interest. But then the footnote goes on to say that could have been challenged on appeal, but was not. My understanding is you have not raised this on your appeal and you have not challenged this in your appeal. So that language would at least suggest that the timing is something I can consider.
It might, Your Honor.
I don't have to, and I'm not saying that I will, but it's something that I can consider.
I think, Your Honor, the most important thing in 60A here is to make sure, basically, and that's the whole purpose of the rule, is to make sure that what the court intended to decide is what actually was entered on the docket by the clerk here. So I think the interests of justice that generally applies of why we're doing this thing, going back even before the rules of civil procedure, going back to the Board of Trustees case, the 1973, I think, SJC case, which we cited too. In that case, the court wants to make sure that we get the situation right and that what is proper and what should be done is actually done. So under O'Malley, which is a footnote dicta, because that really wasn't what was before them, they're citing to Frank the Frank D. Wayne Associates versus Cussler case. And in that case, the court does use that language, says if you raised an appeal but didn't address it after we send it back down, we have an interest in finality of judgments. And here there's no finality of judgment, and Rule 60A specifically says during the pendency of the appeal, which is where we are right now.
So when did you first learn of this issue?
I learned of this issue, Your Honor, and that's falling on me as the lawyer. I learned of it after we had filed our initial brief on this case.
And so tell me if you could give me an approximate date as to when you learned of this.
I believe I appreciate this issue in approximately that this was an issue in probably November of last year, Your Honor. At that time, the court was staying the case.
Okay.
Honestly, I didn't appreciate that was something that I saw interest, and I generally interest is added onto issues. And then I was looking at this around that time frame. And again, I don't have the exact date in my head, but it was around the time that
I appreciate your candor. And so you filed your appellate brief, I think on May 5th of 2021. And then if you learned about this in approximately November of 21, why did you wait until April of 2022 to file this? I understand, I'll preface that by saying, I understand the case was stayed, but the appeal was stayed, but I don't think there was anything precluding you from filing this motion in November, December, January, February, March.
Yes, Your Honor, but my issue is the whole case was stayed. Counsel was having health issues at that time. And I don't know, one, if I file a motion at the appellate court at that time, which I think the request for leave to file 60A would go here, and counsel is unable to respond to it until the case is one stayed and two counsels out of the office. I don't want to file something while counsel is in a bad way, Your Honor, that he's unable to respond to. I didn't want to be like, hey, look, this guy is ill. I'm going to run down and throw a motion in front of him, which he would then have to respond to or get someone else to respond to, or the court wouldn't act upon it. So I didn't see it as necessarily an issue that could be addressed until counsel was able, and two, that the court would address until counsel was able.
Okay. So let's move then to the substance here. Here's part of my understanding, and you can correct me if I'm wrong. I think your argument is that while attorney's fees are the damages in an underlying case, in a duty to defend case, in which case, in that circumstance, prejudgment interest can be added to the judgment. You're saying that here, because of the settlement that already occurred, the attorney's fees that are being sought are not for the underlying matter, but they're the fees being sought in the present matter. And therefore, prejudgment interest doesn't apply as they would in any sort of 93A case. Is that sort of the substance of your argument?
Yes, that would be correct.
Perhaps poorly articulated, but is that what you're
I think that's the gist of the argument of where we're going at it. In the underlying case, it's issue of attorney's fees would be damages because it is something allowed for under the contract. Attorney's fees in a duty to defend case, which is a very unique issue, other than punitive damages allowed for by statute, are not part of that underlying damages. Rather, they are for the substantive action. So correct, Your Honor. And they're not something that is, they're not, a plaintiff is not entitled to them until the court rules that we violated the duty to defend.
So that begs the question, assuming that's correct, what are the damages in this case before me?
The damages and the underlying appeal here, yeah.
Well, the damages, yeah, in this case.
In the appeal.
The lawsuit here against Hanover brought by IMS. They sought a declaratory judgment. The judge awarded what she called damages, which I believe were the attorney's fees divided among three firms, disproportionately or unequally. And if those aren't the damages, what are the damages here? Are there no damages? Is it just a deck action with a lawsuit for fees, as a lawsuit for fees, and that's it?
Well, yes, Your Honor, that would be our position. There were attorney's fees in the underlying case that were at issue. There were two issues in this coverage action. One was the fees and indemnity paid in the underlying case, and two, the right of the insured to be defended in any action stemming from it's stemming from the underlying claims. It was, I believe, it was a False Claims Act, or an FCA action. So any right of the insured to be defended in an underlying case. So two issues: the right and requirement of Hanover, the Hanover entities, to defend the insured, and two, any requirements that Hanover repay fees and indemnity for that underlying case. Ultimately, the trial court ruled that the insured had already been compensated for those underlying fees by another insurance company in a separate declaratory judgment action. But that didn't change the fact that it was still ordered us to theoretically defend the insured in these types of claims.
Pursuant to the judgment at issue in the case before me right now, the damages, I believe, were listed in the judgment as, I think, I can pull it up right here, but the damages were delineated as, hang on one second. My apologies. It was a little slow today, I apologize, but looking at the judgment, single damages in the amount of $59,984 with prejudgment interest. So I guess my question for you is precisely, what are those damages? I think those damages here are the attorney's fees, not from the underlying matter, but the attorney's fees for this very case, this action.
That is correct, Your Honor. I think you were looking at the judgment, which would be, I think, the clerk's entering of them. I do appreciate Judge Sullivan's
entry in the order of Judge Sullivan from May 11th of 2020, ordered that judgment enter in favor on count 4 of the complaint, judgment entering in IMS's favor on counts 1 and 3, Hanover liable for damages to be paid to IMS in the amount of $59,000, comprised of fees to the various firms. Correct?
Correct, Your Honor. She used the term damages, but I don't know that that is outcome determinative of what, how she exactly used the, I don't think it's an inartful term to classify what is being awarded by this court. I suppose technically they would be damages in that any amount a defendant is ever obligated to pay would be damages, similar to statutory costs and fees. But I don't know.
It's what she said. So are you saying that she's mistaken?
I think they are technically, Your Honor, damages in that they are fees that a party is obligated to pay. I don't know that they are it's the same category as damages would be, that is the underlying fees.
Okay. So are you arguing that prejudgment interest is just that the judge was not required to add prejudgment interest here, or that the judge as a matter of law was not allowed to add prejudgment interest here?
I am arguing, Your Honor, that the prejudgment interest should not, as a matter of law, should not have been entered in this case.
Okay, and what's your best authority for that?
Best authority for that, Your Honor, is there's several cases on the issue of what the particular amount of damages are. There's the federal district court case we cited to in.
Yep, I've read everything. So that's what's the best Massachusetts state court case you cite for that? You have for that proposition?
It was not specifically put in the state court case, Your Honor. It's the nature of the damages themselves. Under the general theory of how attorney's fees are computed, they are not entitled to be awarded until a plaintiff is not entitled to them until the actual court orders them. For instance, in the case of, one moment, Kraft v. Kane, which is a Massachusetts appeals court case, not dealing with the duty to defend, mind you, 65 Mass Ave 322. There was no prejudgment interest on that particular amount of attorney's fees because the party was not entitled to those fees until the court had actually made the ruling on it. And I think that's a similar case to how Rubenstein versus Royal Insurance Company has ruled on the nature of these fees in a duty to defend case. You know, it says the entitlement to an insured of fees and costs incurred in establishing a duty to defend depends exclusively on whether coverage is ultimately determined to be the case. So until the court finds that there is coverage and the insurer violated the duty to defend, there's no entitlement to fees.
Would you agree that post-judgment interest is automatic in this case, as in just about any case?
I think post-judgment interest is automatic, and pretty much I've yet to find a case where there's not post-judgment interest, and even on fees like 93A, there's post-judgment interest.
Same. So doesn't that beg the question, why would the judge, Judge Sullivan's a very good judge in my view, and why would she put then plus interest in her order, which was also reflected in the judgment? I mean, it seems to me if she did that, by definition, she almost would not be referring to post-judgment interest. I mean, that would be superfluous.
Well, Your Honor, if prejudgment interest is also automatic under 6C, wouldn't it also be superfluous for her to put the language in there as well? I mean, I think that is an automatic, as required by statute. It's it's.
But under your
ministerial.
reading, I think you've just contradicted, perhaps not, but you may have just contradicted your earlier argument, which is, as a matter of law, it couldn't be allowed here. And perhaps she disagreed. She viewed the fees here as damages. She may be wrong.
But
isn't that a more reasonable reading of her order?
I don't know it is, Your Honor. And I think one possible way to allow this is to allow Judge Sullivan to rule upon what her order was. If she allows to be rule upon the 60A motion, as happened in some of these cases, the judge goes back down and says, well, no, I didn't intend for this to be the case. At that point, we have what her decision is on the issue.
So assume hypothetically that we sent this back, that I gave you leave to bring this case back to Judge Sullivan. Frame the question that would go before her.
Question for Judge Sullivan to decide would be whether she intended and whether or not the court ordered there to be prejudgment interest on the attorney's fees award that she gave the plaintiffs in the case.
What if she says yes? Could you appeal that?
I think under those circumstances, Your Honor, I do probably run into issues with 59E and with 60B in the time frame of bringing the motion.
So answer my question. Could you appeal her decision?
I'm not sure that appeal would be timely, Your Honor, if I brought it to before. I don't think I could, frankly.
All right. So are you representing to me that if we were to do that and she answers, yes, I intended prejudgment interest, you would not appeal that?
I may appeal that, Your Honor. I'm not sure that I'm not sure that I'm not sure what I would do in that circumstance, frankly. So I don't know what we would do.
Well, if it's not a clerical error, and you're appealing it, what would that do other than just delay the proceedings and have piecemeal litigation before us, which we're not allowed to? Well, we're not allowed to. We are allowed to. We're not supposed to.
Disfavored, Your Honor. Understood. I don't.
I understand you have a client to represent, and you have to make decisions based on consultation with your client. I understand that.
Yes, Your Honor. That'd be an issue I'd have to fully examine on this one. This is a request for a Rule 60A motion. So.
Okay. So I sort of asked this question already, but O'Malley footnote 3. Rule 60A may not be used, however, post-appeal to correct a miscalculation of interest that could have been challenged on appeal but was not. The reference to post-appeal, that language certainly helps you. The could have been challenged on appeal language hurts you. How am I to resolve that?
One, Your Honor, I don't think O'Malley was dealing with this particular circumstance before us. I think the way to really the case to be looking at that one again is Frank D. Lane, which is, I think, the issue there of what would, because that's what O'Malley's relying on. They're citing to it in the footnote 3, which is dealing with a situation where the court wants finality of judgments. And they talk about, oh, you could have raised this. But now at this point, after we have decided and affirmed the appeal, it is too late. I think that's how you have to look at it altogether, as does Rule 60A itself says, provides for this circumstance, which is during the pendency of the appeal, this procedure is allowed to bring a Rule 60A motion.
Before I go to Attorney LaFortune, I've asked you a lot of questions. Is there any issue that I did not allow you to address or that you would like to address right now?
I think you've addressed all of our issues on this one, Your Honor, as far as it is.
Okay, thank you.
Thank you.
Attorney LaFortune, I'm going to start with the same question I had for Attorney Melville, which is, what is my standard of review on this action, not on this action, on this motion?
Well, it depends on how you characterize the court's order. If the court,
it's a 60A motion though, right? That's before me.
It is a 60A motion, and you would have discretion if it was a clerical error. It's not a clerical error. It's a at worst, it's a substantive error. Yeah,
how do we know that? I mean, just assume for the sake of argument, right? Right now, I can't get into Judge Sullivan's head. So assume for the sake of argument that Judge Sullivan and I were chatting, and I said, geez, strange that you added prejudgment interest on that. And she said, oh, no. When I said interest, I meant post-judgment interest. So that had to be the clerk's error.
No, the order doesn't say that. It says damages. It specifically says damages and says plus interest. That amount could have been paid right then and there by Hanover. I mean, the order speaks for itself in the sense of characterizing the legal fees as damages.
What is your best, I'm sorry to interrupt, but what is your best case for the proposition that attorney's fees in this context constitute damages?
Well, and I addressed that in the footnote. I don't think the case law has been decided in the duty to defend issue. Whether legal fees can be, interest can be added to the legal fees. If you look at the district court case, it cites a 93A case. However, the SJC has specifically said the intent is to make the insured whole. And interest, there's other case law that's saying interest is necessary to make a party whole. So I don't think the specific issue has been addressed yet. But I think Judge Sullivan, if you look at that order, specifically says constitutes damages and interest. Her opinion is that the interest is applicable in this type of case on a duty to defend case. And it's a substantive error. It's not a clerical error.
That is certainly one reading of it.
Well, well, I guess Your Honor can read it said, but it specifically says damages plus, and it adds plus interest. And most of the cases that I found, I mean, that I've dealt with, I've never seen a judge specifically add that language plus interest. The clerk usually does it. Judge Sullivan went out of her way to characterize those fees as damages. And again, based on my, that this specific issue wasn't raised, but I specifically said throughout this case that the SJC is intended to make the insured whole. In this case law that says interest is part of making a party whole, but she specifically says as damages, and she specifically says plus interest. I mean, you'd have to, and if there was any miscalculation on that, the duty is upon Hanover to bring a Rule 59 motion or to appeal that decision. Or bring a 60, if there's a mistake, it's a 60B motion. They didn't do any of that.
Let's talk about O'Malley at footnote 3. You're familiar with it, I assume?
Correct. I'm the one who raised that at footnote 3. And
so what do you make of the fact that the court, the SJC there, used the words post-appeal to correct a miscalculation of interest? And I know you're arguing it's not a miscalculation of interest, and I understand your argument. But put in the context of this case, doesn't post-appeal suggest that a 60A motion, which has no time limit, by the way, can be brought at this time, and in my discretion can be allowed? Had this been after the appeal had concluded and the rescript had issued, your argument has more teeth.
I think this, I'd have to go back and look at that O'Malley, but I think it says that could have been briefed. That could have been addressed on appeal.
Rule 60A may not be used, however, post-appeal to correct a miscalculation of interest that could have been challenged on appeal, but was not.
Right. So they didn't challenge it on appeal. They've admitted that they didn't find out about the issue until November of 21. They could have challenged it. They could have brought a Rule 59 motion. They could have brought a 60B motion within 1 year. This isn't the intent of 60A. 60A is intended, if Judge Sullivan said I award $1 million in interest, and it's obviously a typographical error, those are the situations that 60A is intended.
What's your best case that describes, that explains the intent of 60A as you're arguing?
Well, I think I cited in the opposition. I don't want to confuse the two cases, but I do cite it in the opposition that the single justice, Your Honor, has to look at it whether it's a clerical error or a substantive error. And a clerical error is typical clerical error. I mean, I've run into it in a number of cases where sometimes even the clerk reverses the parties. Those are clerical errors. But I specifically cited, and I'm sorry I can't bring it up, but if you want, I can get my staff to bring the memorandum. But it's specifically in that memorandum where the appeals court and the SJC say it's a case-by-case basis, but you've got to look at it as 60A as being purely a clerical error. If the judge made a mistake as to the issues, factual, law, or anything else, 60A doesn't apply. But I specifically cited that in the brief, Your Honor.
Understood. I wish the cases did a slightly better job of they say when it's substantive versus a clerical error, they don't give a ton of guidance though. I guess that's why they say you do it on a case-by-case basis.
Yeah, it's a clerical error would be as if I mean, what we typically think of a clerical error. You know, we forget the word not, or somebody puts in an extra zero. Those are clerical errors. This is a specific order awarding us damages and plus interest. It's incumbent upon Hanover. That's what it says, though.
Or you say the word interest when you mean just post-judgment interest.
She doesn't say just post-judgment, it's plus interest. And then
Agreed.
interest was calculated.
That's exactly what I said.
And interest was.
I'm sorry to interrupt you, but I'm going to. I heard you earlier when you said typically the judge, most judges, not all, don't include the word interest. Usually that's just something that is added by the clerk subsequently. So that begs the question, by adding it here, what was she doing? Is that just her practice to do so in all cases? I don't know. I don't have before me all of her prior judgments, so I don't know the way she frames things specifically. One reading of it is she just meant post-judgment interest, in which case it's a clerical error. Another reading of it is post-judgment interest accrues in every case, so she had to be referring to pre-judgment interest. I'm trying to find some guidance as to how to decide this. The case law thus far that I've looked at is not overly helpful. So I'm just letting you know where I'm at. So with that in mind, I just have one more question for you, and that is, you said at the outset that you think I have discretion on this motion. What is your authority for that?
Because I don't have any authority for it. If it was found to be a clerical error, and I don't see how. Well, I've already argued the point.
I definitely understand your argument. I'll give you the same opportunity.
And the additional argument is, which they've never addressed, and I guess they have, by saying they made a mistake, but they should have brought a Rule 59 motion or a 60B motion, or they should have appealed it, and they didn't. This piecemeal appeal, I don't even know how mechanically it's going to work, because I've appealed a decision arguing the settlement agreement provides that we only paid half of the underlying damages. I mean, to me, mechanically, and Your Honor would know better, mechanically, we should let the appeals court make this, if there's no timeline, make the decision on this and see where we stand. I could be added a lot more in damages. I don't know if Your Honor's had an opportunity to read that settlement agreement with Central. It specifically says they're only paying half the damages, and that I'm entitled to go, meaning the underlying damages in the Connecticut lawsuit, and I'm entitled to pursue it against Hanover in this case. It seems to me, and Hanover is appealing the liability portion. It seems to me that the better route here mechanically, even if Your Honor disagreed with my arguments in my opposition memorandum, so let this go through appeal and have the appeals court sort out these issues, and then we can address the issue of interest. Because the interest, if I'm correct, and I mean, the language of that settlement agreement is clear that we only paid half the damages, underlying damages from the Central lawsuit, then I'm automatically entitled to interest on those underlying damages. The best process here is to let this go to appeal, let all these issues be sorted out. There's a number of issues, and in the event Hanover wins the liability, we don't even have to address this. So that's it's going to provide a host of complicated issues, because when I have another set of appeal on the way Judge Sullivan rules, I'm going to have another briefing issue, and which may all be rendered moot depending on what the appeals court of the SJC rules in the underlying appeal in this case.
So here's likely my final question, and that is, am I allowed to take into account the 2-year delay in filing the 60A motion, or slightly less than 2 years? And if so, under what authority?
Well, I guess the authority would be the O'Malley case, and the delay is always taken into consideration, given the number of opportunities Hanover had to address this issue. Again, repeating myself, Rule 59, 60B, and appealing it. They put the parties and the court in a very difficult position, even if you're assuming Your Honor disagrees with me. And I've just explained why. I mean, we could have a number of outcomes. Let me give you another example, Your Honor. All the judges, including in the IMS Central case, including in the New York District case, have ruled that IMS would be entitled to legal fees throughout the entire proceeding. That means from the inception all the way through the appeal. There's many cases directly in point, including my other case, an IMS Central, Judge Hillman, who's a very good judge, interpreted Massachusetts case law as having legal fees all the way through. Judge Sullivan interpreted I was only entitled to legal fees from the inception of the case until the summary judgment decision in 2016. There's a huge gap there, including the trial, where this court may, on appeal, 3-panel, may say no.
That's being argued in your, that's in your cross appeal. I'm aware of it. So
Yeah, well, so we don't even know, if I get all those legal fees, the interest calculation may even change. And so it's something that I've argued very strongly. The untimeliness of this has in essence become problematic just for the handling of the underlying appeal. It shouldn't have waited.
What do you say to Attorney Melville's comment that although he was aware of this, became aware of this in November of 2021, he waited 6 months in part as a courtesy due to health issues?
Yeah, I've got to take Attorney Melville and I get along very well. I've got to take him at his word. I was very ill. I'm not going to sugarcoat it. I had to undergo emergency open heart surgery, and I only have one artery left. I was incapacitated. I was in the ICU for 7 days. So I don't know how my office would have responded. We probably would have, I think the better course would have been to file it and then ask for a stay until I get better. I mean, but I understand Attorney Melville was trying to be courteous on that. So I was very ill, Judge. I mean, there's no.
I appreciate the kindness and courtesy between counsel. That's nice to see. And so I appreciate that. So with that said, Attorney LaFortune, do you have anything else you would like to tell me?
No, I've made my arguments in the opposition memorandum, and I essentially have 3 arguments. So they waited too long. It's not a clerical error. Shouldn't be piecemeal appeal, and the better approach is to let all these underlying issues be decided on appeal, and then we can take it from there. I mean, if they prevail, they've cross-appealed. If they prevail on the liability issue, this is all moot. And then you've got another issue of if Judge Salt, we're going to have to try to get legal fees from arguing a 60A motion below. It's going to be another set of disputes over legal fees.
Okay. Then I'd like to thank both counsel. Excellent argument. Cases under advisement. And that concludes our session. Thank you both.
Thank you, Judge. Can we leave now?
Please.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
Thank you, Sean. Appreciate it.